When our clients are negotiating software agreements, they often don't know what to focus on. My name is Marcus Harris. I'm a software and technology attorney. For the past 20 years, I've been focusing my practice on drafting, negotiating SaaS-related agreements, software-related agreements, and litigating failed software disputes in courts and tribunals across the country. I think when you're negotiating software agreements, you really want to focus on the software license grant. You want to focus on the description of the software, and of course you want to focus on the remedies and warranties that software vendor is going to make available to you. With respect to the software license grant, I mean, for a software license, this is really the meat of the agreement, and I think the vendor is really going to be incented to have the most narrow software license grant that it can provide you. And the reason is it wants to narrow your ability to utilize that software so that it can preserve future revenue streams. Your goal as a customer really is to maximize that grant and so that it really can provide you with maximum flexibility and all the indicia of owning that software as if it was your software and not subject to a license. I think if you don't do that and you've got some narrowly focused software license grant, it really increases the likelihood of allegations of breach, a dispute down the road, and certainly I think the vendor is going to try to extract additional fees for you from supposedly unauthorized use of that software product. Kind of a sleeper issue in these agreements that we run into on a pretty consistent basis is how are you going to describe the software that you're actually licensing? And I think the default and the assumption by many of our clients is to have kind of a broad, open-ended description of the software, thinking that that gives you some sort of an advantage with the vendor. And I think that really is a mistake. You want to have a very finite description of what you actually have a license right to use. You want to make sure that you describe the functionality and the features, any performance requirements associated with that software. And the reason really is to avoid a dispute. I think if you've got a broad, open-ended description of what the software is, the software vendor can always come back and say, well, yeah, you're licensing this, but you don't have the right to use this, and now you've got to pay a whole bunch of additional fees. And I think by having a tight description, you're really mitigating the likelihood of some dispute down the road. The other thing that we run into on a pretty consistent basis is what are the warranties associated with that software product that you're accessing? What is it going to do? What is it supposed to do? And typically, you have a software warranty, and it's almost always a warranty of time, and it's a warranty of reference. And what I mean by that is, the warranty points to something external outside of that contract, and it can be mutually agreed upon specifications, it can be the vendor's documentation for that software, or it can be something like generally accepted industry standards. Whatever it is, it needs to be objective, and it needs to be in the contract. You also want to make sure that you have an understanding of how long that warranty lasts. If you've got a warranty that lasts 6 months from the date that you signed the contract, you really don't have very much, because if it takes a year to integrate or implement that software product, the warranty has expired by the time that you're actually using it. So you want to make sure that you're thinking about the time associated with that warranty, how long it runs, and what triggers the warranty obligations. And then finally, speaking of triggering warranty obligations, if the software doesn't meet that warranty obligation, what does the vendor have to do? And typically what we will see is something like, repair, replace, and refund. And there's a lot of nuance associated with each one of those things. If the software doesn't perform as warranted, does the vendor get to, try to attempt to fix it, to make it conforming? How many chances do they get to do that? How many bites at the apple, so to speak? And if they can't do that, how much money are you getting back? Are you going to get a refund? Is it for a portion of the software? Is it for the whole fees that you've paid? And what's the cap on the amount of money that you can get back? And I think if you focus on these three items within that contract negotiation, you really are going to set yourself up for success. You're going to mitigate the likelihood of a dispute going forward, and you're going to maximize your ability to utilize that software over the life cycle of your utilization of the product and your relationship with that particular software vendor.